Thank you all very much. We will begin in just a couple of minutes. It is. Thank you all very much for your patience. Good evening. I'm County Supervisor Joe Simitian. I represent the 5th Supervisorial District on the Santa Clara County Board of Supervisors. And for those of you who have no idea what the 5th District is, that is the northwest portion of Santa Clara County. It includes all or part of 8 different cities in the county, as well as some significant unincorporated areas as well. So let me thank you for attending our 5th annual town hall about Lehigh cement plant and quarry. I began holding these meetings when I was first returned to the board in, 2013, 2014, because it was my sense that the community had questions and wasn't always sure how to get answers to those questions. So tonight the hope is that we'll be able to get answers to the questions you and your neighbors have. We've got a panel of folks I'm going to introduce in a minute who represent various federal, state, and local regulators who are here to answer those questions and offer some brief background as well. I'll offer a few comments to get us started on all this, but then we'll get to questions right away. I should begin by saying, forgive me, I'm still fighting off a cough, and so if I I'm a little less than gracious and just wet my whistle during the course of the evening, I hope you'll understand. And I do think it's helpful for the conversation to start by sharing with you all that before I returned to the board in 2013, I had been in the state legislature for 12 years, and before I returned to the board in 2013, the Board of Supervisors that had been in place took two important actions. One of those was that in 2011, the Board of Supervisors made a determination as to what are called vested rights. And the board at that time determined where mining activities could occur without a use permit, meaning without a new permit, and where a use permit would be required because there were not vested rights. And my understanding is that about 2,200 of the 3,500 acre property fits that description, is vested for mining activities. Proposals to mine outside that vested area require a use permit from the county, and that is a set of decisions, as I said, that was made back in 2011. Then in 2012, again, I guess that would have been the year before I returned to the board approved an amendment to the quarry's reclamation plan, and that encompasses about, more than 1,200 of the 3,500 acres. The reclamation plan outlines the plan and the timing for how the site will be restored at the conclusion of mining. And so changes to the existing mining footprint that are within the vested area, I'm sorry this is all so technical, but we'll have folks to answer questions in a minute. Changes to the existing mining footprint that are within the vested area would likely require an amendment to the rec plan. Now, I should say both of those determinations by the board back in 2011 and 2012 were not without controversy, and both rulings were subject to judicial review, which is a fancy way of saying there were court cases. And in both cases, the county prevailed, so the vested rights and the reclamation plan are in place as approved by the board prior to 2013 when I came back on the board. So that's the world that I inherited when I came back and that many of you in this room have lived through over a period of time. And I want to be clear, the fact that the cases were upheld doesn't necessarily mean that they are good policy or bad policy. It just means the court found that they are legal. So since being sworn in for my return here, so I've been back on the board now for about 7+ years, in January 2013, we've taken some steps to increase oversight in ways that are sometimes modest, but that I hope collectively will have a good result. I think it was in April of 2014, after I'd been back a little longer than a year, that I issued a memo to the then Director of Planning and Development. I think we had copies out in the lobby, did we not? Christina, thanks. And essentially, I asked for 3 things. I asked that the county increase the inspections on site so that we had monthly visits by county staff on the quarry property. Prior to that time, I'm told, typically folks would be out there maybe a couple of times a year. I felt that that was not adequate. I also felt that we couldn't provide assurances to members of the public about what was happening on the property if we didn't have county staff out on the property. So those visits are now something more like monthly. The second thing I asked is that the county host a twice yearly meeting with all of the various with all of the various regulatory agencies that play a role on the site. And I thought that was helpful and important because, as you are about to hear in a few minutes, there are a lot of folks from a lot of different levels of government who play a role in this process. And it is confusing even for me as a county supervisor, and I think for members of the public, it can be very challenging to try and keep track of who's in charge of what, who's responsible for what, and then to nail down the information about who has actually done what. And it seemed to me that one of the things we might do to make the process work a little better functionally, substantively, was to make sure that at least twice a year all those folks got together, sat down in the same room, and talked to one another about who was taking care of which piece of business. That has now happened over the last half dozen years. And then I thought it was important that following those meetings that there be a report out, if you will, to the community, and that's what tonight is about, that we have a report out once a year that allows the community to both receive the update from the various regulators and to ask the questions. So this is the 5th, I believe, of these. We've adjusted the scheduling a little bit to accommodate the community's interest level and over the years, but this is the 5th such meeting where the public can get an update on regulatory activities and ask questions. And so, again, my thanks for you being here. I should mention that as part of the ongoing review process as well, I think it was 2014 when I asked my staff to simply review all of the conditions of approval for the cement plant and quarry, just to sort of make sure that things were being adhered to. In fact, as a result of that review, we identified a relatively small bond. I think it was $75,000, if I remember correctly, a performance bond that had not been posted. And working with both the folks at Lehigh and our county council, our legal office, we made sure that the bond was restored and in place as it is today. In 2015, as we worked with community members, it was becoming increasingly clear to me that the county's website was not as helpful a tool as it could and should be. So the website has been updated, and we hope you find it a more useful way to access the information. If you have comments or questions about that, please do share them, because that's always a work in progress. Also, in 2015, one of the things that we began to do in my office was to schedule a monthly call between somebody in my office and the management at Lehigh, so that every month we had a phone call where we could share information. We could say, hey, here's what we're hearing. What are you hearing? We could say, what about this? What about that? I participate only occasionally. Usually my chief of staff, Christina Loquist, who some of you have met earlier, is on that call, but if need be, I can participate in the call. And we have typically dealt with management at the highest level, including the president at Lehigh, just to stay in touch. The other thing I would say is that in 2015 and 2016, and I know from some of the faces that I recognize, we had need to step up monitoring and oversight with respect to noise complaints that we had received at the county. And I think many of you know that in 2018 there were some changes that took place at the facility, which I think for the most part have had a good result. And then in 2018, my office in the planning department began receiving complaints about increased truck traffic between Lehigh and Stevens Creek. And county staff again investigated and determined that there had been violations at both sites and issued notices of violation to both parties. And the truck traffic between the sites ceased, and Lehigh submitted a reclamation plan amendment to address the violations that were recorded for the grading they had done. So hang in there, I'm almost done before we get to your questions and these folks here. Last year, I thought that as we were working these issues through, there still was a need for additional mechanism at the county so that folks could be updated on the status of both Lehigh and activities at Stevens Creek Quarries. So I asked that that update be added to the agenda of one of the board committees I sit on, which is the Housing, Land Use, Environment, and Transportation Committee. We now get those updates there. I think the most recent one came in December. I thought it was helpful. Hope you did as well, for those of you who participated. And in fact, I believe we had a copy of the update out in the front when I came in, and if you didn't grab one, you may want to on the way out. Before we move into this, there are some folks I want to recognize and thank for their attendance here. And even as I speak, they continue to arrive. We want to thank, and please hold any applause, Juliana Park from Assemblymember Evan Lowe's office for being here, and I see Tom Pike right here in front of me from Congressman Ro Khanna's office, and I saw Leslie Bulbeck from Assemblymember Mark Berman's office. My colleague, Dave Cortese. Dave, are you in the corner? Thank you very much for being here. This is Supervisor Cortese, who is with us as well. Lisa Chung from Senator Jerry Hill's office. Thank you to you, Lisa, and to the Senator. Anita Anandar, a council member from Los Altos, who I walked in with, so I know she's right in front of me again. That's the hard one to see. Darcy Paul, the Vice Mayor of Cupertino. John Willey, the council member from Cupertino, both right here in the front. Also, I saw Patrick Ahrens walk in. Thank you, Patrick. Patrick is a trustee with the Foothill De Anza Community College District. And I didn't see her, but I'm told Yuriko Kishimoto is here, right there. Thank you. Hi, Yuriko. Yuriko is from the Mid-Peninsula Open Space District. Did I miss any of our elected officials? If not, then I should also just note, in addition to the county staff who are up here, I really am appreciative of the fact that our county planning director, Jacqueline Anshano, is here. If you would stand, thank you, Jack, for being here. And our deputy county executive, Sylvia Gallegos, had planned to be here. Sylvia, there you are. Thank you very much. So lots of folks from officialdom here, both to hear from the panel, but also to hear your questions. Could you please join me in thanking them for being with us this evening? And I know we've got some Water District folks here. Were any of the board members with us tonight? Thank you very much. Is that, I can't see from here, is that Nye? Nye. Hi, Nye. This is Nye Shui from the Valley Water, and we appreciate your being here with us. Thank you so much. All right. I also need to thank the City of Cupertino, both for providing the venue and perhaps most importantly for the refreshments that are out front. So thank you. Every year we do this, the city is kind enough to host us. They've also made the arrangements for taping. As I said earlier, I want to just briefly explain how we're going to let the evening unfold. I hope you signed in when you came in, because if you did, that will ensure that you are added to what we call our interested parties list. And you will receive periodic updates about what's happening on Lehigh as they develop, as well as from my office. There are also, as I've mentioned a couple times in passing, various handouts available out in the front. And in addition to the agenda and contact list, there are copies of the December 2019 update that I mentioned that went to the committee, our Housing, Land Use, Environment, and Transportation Committee. And they're also available on the website if you don't grab them tonight at my office. Now, I'm going to start off by asking the panel to introduce themselves. Then I'll ask them some questions that are the ones we get most commonly in my office to just sort of lay out a baseline. And I think that'll probably take 30 minutes, 40 minutes based on my experience. I see Karen Holman from the Mid-Peninsula Open Space District has walked in as well. Thank you for being with us, Karen. And after we do the introductions and the questions from our office, which are sort of the ones we get most frequently, we will take questions. You should all have question cards there. If you have a question you would like to ask, please just raise the card. Somebody from my office will swing by and pick it up, and we'll then ask them to sort out the questions so that we can do this in some coherent fashion. Full disclosure, we won't have time to get to all the questions, but as we have done in prior years, and I really appreciate the panelists helping us with this, any question that we can't get to tonight, we will ask the panelists or some other appropriate party to answer in writing, and all of the unanswered questions and answers will then be posted on our county website. And I think we use both the planning department and our office as well. So you should be able to get to an answer to your question one way or another. The other thing is occasionally we get a flood of questions from one person, and I just want to tell you, again, full disclosure, we sometimes have to say we can't get to all 15 of your questions. We can get to one or two. We want to make sure that there's time to get to questions from other people. So again, if you have a question, please write it down, hold it up, we'll grab it. We are going to wrap up promptly at 9, so that's one thing that I think is important, and I probably should just mention as well that tonight's meeting is both live streamed and it's also taped, and it will be available on the city's YouTube channel, and we'll put a link on that, on our website as well, so that people who just didn't get enough tonight want to do it again, have a chance to do that, or if folks couldn't be here, they'll get a chance to do that. There was, as I mentioned in passing earlier, one of these interagency meetings that I talked about. That happened, I believe, on February the 6th, if I'm remembering correctly. Yep, I see heads nodding. When the various agencies attended and shared their oversight activities from the past year. My staff was in attendance, and I understand there's quite a bit to report out, so I am looking forward to hearing that as well. Panel, let me ask you to briefly introduce yourselves, starting at this end of the table, and if you would do that by telling us your name, your agency's name, and just a 1 or 2 sentence summary of the type of oversight your agency provides at the Lehigh site. So, your name, I don't mean to hover, but your name, your title, your agency, and what does your agency do that is connected with what we're talking about tonight? Rob?
Absolutely. Rob Eastwood. I work for the County of Santa Clara, Department of Planning and Development. I'm the planning manager. I manage planners in the office that oversee use permits and oversee, in this case, our SMARA program. So we implement the Surface Mining or Reclamation Act and reclamation plans that are required of all quarries and the planners that manage them.
Thank you. Next.
My name is Rob Salisbury. I'm a planner with Santa Clara County, and I administer the county's SMARA program. So I schedule and conduct the annual SMARA inspections, review the financial assurance cost estimates, and reclamation plan amendments for Lehigh and the other quarries in the county.
So just to be clear, we have 2 guys named Rob who are both planners and both have beards, yes? All right. So Rob 1 and Rob 2, that'll make it easy. Ms. Pianca?
Good evening. Elizabeth Pianca, Lead Deputy County Counsel with the Office of the County Counsel for Santa Clara County. I advise the Department of Planning and Development and the county as a whole on land use matters, including Lehigh.
Good evening. I'm Michael Rossi. I'm also with the Office of the County Counsel. I'm also a Lead Deputy County Counsel. I supervise a team that addresses civil enforcement matters within the county, and we advise specifically for this evening's purposes on compliance matters regarding Lehigh and Stevens Creek quarries.
Hi, good evening. My name is Joel Jones. I'm the acting deputy in the Enforcement Division in EPA Region 9. What we do is we implement and enforce the Clean Air Act and Clean Water Act in oversight for the state agencies.
And Mr. Jones, before we leave you, I can see it on the screen, but I'm not sure everybody else can make the distinction. There's a state EPA, there's a U.S. EPA, and you are with?
The U.S. Environmental Protection Agency.
Thank you very much for that clarification.
Good evening. I'm John Marvin with Bay Area Air Quality Management District. I'm a manager in the Compliance and Enforcement Division. We regulate air quality and the rules and regulations associated with air quality at the facility. And my oversight responsibility with this is with an inspection staff that conducts inspections and determines compliance at the facility.
Thank you. And before we go to our next panelist, could you mention your agency name one more time, please?
That's Bay Area Air Quality Management District.
And sometimes it's referred to as?
BACMed.
Thank you. For those who aren't familiar with the acronyms, the nicknames, the shorthands, I just want to try and make sure that if you hear something tossed out, you know what it is we're talking about. But I very much appreciate hearing the full name of the agency so that folks know who's who and what's what. Thank you. And next to you.
Good evening. My name is Nicholas Maiden. I also work at BACMed. I'm a manager within the engineering division that evaluates permit applications from some of the more complex facilities, including the Lehigh facility.
Thank you.
All right, good evening, everyone, and welcome to Cupertino. I'm Roger Lee. I work for the City of Cupertino. I'm the Director of Public Works. And while Lehigh is not within a jurisdictional area of Cupertino, it has a lot of effects on our residents. So the city, on behalf of its residents, is very concerned about the air quality, noise, water quality. So we monitor those things. Very interested in the different things with the reclamation plan amendments that are going on and keeping our citizens informed. Also the truck traffic, things that are on our city streets. Those are all the things that we're interested in.
Thank you. Next panelist.
Good evening. My name is Rochelle Gaddy. I work with the Santa Clara County Department of Environmental Health. I am the Division Director for the Consumer Protection Division, and we enforce the noise program in the county of the Santa Clara County Ordinance.
Thank you. And next panelist.
Good evening. I'm Jennifer Kaah. I'm the Hazardous Materials Program Manager with the County of Santa Clara's Department of Environmental Health, Hazardous Materials Compliance Division. We are authorized by California EPA, or Cal EPA, to implement several state environmental programs related to hazardous materials that are collectively referred to as the Unified Program.
And next panelist.
My name is Kirsten Struve. Good evening. I'm with the Santa Clara Valley Water District, now known as Valley Water. I'm a Senior Water Resources Specialist, and we provide water resource management for the county, including groundwater management, wholesale water supply, flood protection, and stewardship.
Thank you so much.
Good evening. I'm Lisa McCann. I'm the Assistant Executive Officer with the San Francisco Bay Regional Water Quality Control Board. We are a regional office that's part of the State Water Resources Control Board, which is a board of the California EPA. Our mission is to protect water quality for beneficial uses for humans and protect human health, as well as for aquatic life and the environment. And we do that by regulating pollution discharges from facilities such as Lehigh, as well as with enforcement authorities that we have. We hold 2 orders. We've issued 2 orders to Lehigh that they have to comply with in terms of activities on their site to protect surface water and groundwater, and that sets limits for the amount of loading of various constituents that come off of the site and or possibly could migrate to groundwater. And we have issued enforcement orders for penalties for not complying with these permits in the past.
And next panelist.
Good evening. I'm Lindsay Whalen. I'm an engineering geologist at San Francisco Bay Water Board, and I'm technical staff. I oversee groundwater protection from mining and waste disposal, also the water quality aspects of reclamation I oversee, and I'm the geochemistry technical assistance in the office.
Thank you. And thank you to all of the folks who are here this evening. You know, many of them have come from some distance. We'll have some distance to go at the end of the evening. Like all of you, they've had a long day already, so I very much appreciate their willingness to participate and provide answers to our questions. Let me start with the county planning staff. Mr. Eastwood, that would be Rob 1. Could you give us all some overview about, and a status report, I guess, as well, on any notice of violations that your department has issued, let's say over the last year or two? I am often asked very directly about, are there violations? If so, you know, have they been identified, and what is the status, and what's the consequence? So let's say over the last couple of years, what do we have in the way of violations and any formal action on those violations?
Got it. Happy to. Again, Rob Eastwood, Planning Office. 2 notable violations issued from the county to Lehigh. One was alluded to by Supervisor Simitian, and I believe it was discussed last year. In August of 2018, our inspectors observed quarry trucks at Lehigh delivering material to Stevens Creek Quarry, and Lehigh had created a haul road that had extended beyond the reclamation plan boundary. Upon discovering that, we issued Lehigh a notice of violation. It was a violation of their reclamation plan, and told Lehigh to stop the activity and submit a reclamation plan amendment to include those areas in their existing rec plan. That activity was stopped. A reclamation plan was submitted from Lehigh to the county. I have a date of March 2019, and has since been deemed complete. So today that violation has been abated by Lehigh stopping the activity and submitting a rec plan amendment. Subsequently, in June of last year, on June 13th, our inspectors, actually in tandem with some regional board staff, observed sedimentation and spilling into Permanente Creek. This is near a portion of the mine called the West Material Storage Area. There was some debris sliding down the hill and entering into the Permanente Creek zone. Lehigh is required under the rec plan to install best management practices to manage the sediment so it does not go into the creek. Observing this, our inspectors issued a notice of violation to Lehigh. This was on June 13th of 2019. I believe within a few weeks, the regional board also issued a violation. And subsequent to that, there were some meetings back and forth with county staff and Lehigh. We did issue what's called a stipulated order to comply, and this was on November 8th of last year. This basically directed Lehigh how to go forth, do corrective actions to stabilize the slopes, install best management practices, create stability to address the debris slide and the sedimentation. In January of this year, after receiving the stipulated order to comply, the Lehigh staff did meet with us. They have explained and showed some documentation showing how they have corrected the violation. In response to this, we're looking again at the status of the violation. We did have an independent inspector go visit the site twice in December and January of this year. And right now he's finishing a technical report to determine, is there still a violation? Is there still sedimentation that's going into the creek? Our best management practices have been installed. So at this point, we're evaluating to what extent there's still a violation that we declared in July 9th of last year.
Thank you. One of the things I'm going to do during the course of the evening is, if it appears to me that something may have been overly technical, I will try and turn it into plain English. And some of you who are experts may say, well, it was pretty clear to me, but I can see the furrowed foreheads on others in the room. And the other thing I'll do is, when there's a lot of information, I'll try and sift through and pull the nuggets out, such as they may be. And so, Mr. Eastwood, let me just make sure I got this straight. What I heard was 2 violations that resulted in a notice of violation from the county, one dealing with the haul roads and one dealing with sediment getting into the water. Is that the shorthand layman's version?
It is.
It is, okay. And what I heard is that in response to the one dealing with the haul roads, the hauling has stopped, yes?
That is correct.
And on the sediment going into the water, that one is a work in progress, yes?
It is.
And when I used that phrase with my high school teacher, she said, that means you haven't finished your term paper yet. So is that where we are? It's a work in progress, which is to say we haven't yet got that one fully resolved.
Correct. We're working to try and get an update by the time of this meeting, but at this point, we're still finalizing status.
And I heard you reference, I thought, notice of violations from other agencies in connection with these same activities. Was that right?
That is correct.
So would you just explain briefly how it is that there's overlapping jurisdiction on some of these issues, because the questions that we get in our office are most frequently about people trying to figure out who they should talk to about what issue to get some response.
That is a great question. So with respect to the sedimentation, we do have a bit of overlap, and it's one of the reasons we confer constantly with the regional board. In the Lehigh Reclamation Plan Amendment, there are requirements to control sediment, do erosion controls, to make sure the mining and reclamation activities don't spill over into natural areas in the creek. And per the county's reclamation plan, they have to adhere to those conditions. And that's the violation we observed. Separately, and the regional board, of course, can discuss this more, they have broad oversight on water quality. And I know as a result of our joint inspections, when they saw, I believe, sediment going into the creek, on their own accord, they saw a water quality violation. Of course, they can speak more to this, similar in the same sense what we saw, but under their own laws and requirements, they issued their own violation. So there is a bit of overlap we've discussed constantly between our agencies and coordinating on the enforcement actions. But to answer your question, that's the overlap.
Thank you. And if somebody has a concern, then it's appropriate for them to go to both agencies or entities and express that concern when the time comes?
Yes.
Okay. Before I go on to the next question, which is going to be for Mr. Salisbury, Rob 2, I should mention I saw two members of our County Planning Commission seated here in the audience. So Kathy Schmidt and Vicki Moore, would you both raise your hands so we can say thank you to you for being here? Are there any other members of our 7-member Planning Commission here? I didn't think so. But thank you both for being here. For those of you who are unfamiliar with the process, there are 7 essentially volunteer planning commissioners who hear many of these matters before they get to the Board of Supervisors. Kathy and Vicki are 2 of them, and I appreciate them coming out tonight to stay informed about these issues as well. Let me go back to county planning with this question. Mr. Salisbury, a couple of times we've used the phrase reclamation plan, rec plan, talked about that process. My understanding is, that, as we've heard, that the county has received 2 reclamation plan amendments or applications for 2 reclamation plan amendments from Lehigh. Could you explain what they're for and what the status of them is and what the process is going forward?
Thank you, Supervisor Simitian, I'd be happy to do that. So as Rob Eastwood mentioned, in response to the Hall Road violation, Lehigh submitted a reclamation plan amendment that would amend their reclamation plan boundary to include the newly disturbed area that resulted from the Hall Road being installed. And this amendment then, if approved, would bring those areas into the reclamation plan boundary, and Lehigh would be required to reclaim those areas under the standard of their current 2012 reclamation plan.
I'm going to stop you for a minute and make sure I understand that in plain language, because I see a lot of furrowed foreheads again. It sounded to me, and please, everybody, feel free to say, no, Supervisor, you got it wrong. Here's what it really is. But it sounded to me like you were saying, so in the aftermath of getting that notice of violation, there was an amendment to the reclamation plan requested by Lehigh so that the new reclamation plan would allow them to have the road that is currently not permitted. Is that accurate?
No, not exactly.
Okay. See, that's how it works. So clarify that.
The reclamation plan amendment that Lehigh has applied for would simply bring that disturbed area, the Hall Road, into the reclamation plan boundary, which then, once that's done, it specifies that they have to reclaim that area when they cease their mining operation. So that would be revegetate, possibly narrowing the road width, and other activities to meet the end use of the quarry once the mining activity has ceased.
I'm going to keep pressing on this point because I think it's an important one to folks who are here. If the reclamation plan amendment was granted, could they then reopen the road?
No.
What would it take for them to be able to reopen the road?
The road was designed or intended to allow the transport of material from Lehigh to Stevens Creek Quarry. Lehigh was cited only for the disturbance outside of the reclamation plan boundary. In order to resume the direct transport of material from Lehigh to Stevens Creek Quarry needs to amend their use permit to allow that particular use.
So now I'm going to use my layman's language again. So the violation is about moving stuff around in a way that you call, I think, a disturbance. Is that what I got right?
The disturbance it's a term that we use to talk about any kind of disturbance of land, grading activities.
Yeah, it means something. The word disturbance means something different. There's clearly a disturbance in the community sometimes. It's a little different. But so there's been a disturbance, and the goal with a reclamation plan amendment is to make sure that that disturbance gets resolved. But the point I'm trying to make sure we're all clear on, myself included, is even if that were approved, that would still not allow for the road to be reopened. That requires some activity by folks at Stevens Creek, and it would require approval as well from the Board of Supervisors?
It would be the County Planning Commission that would take an action on the use permit for amendment that would be required of Stevens Creek Quarry.
And could that then be appealed to the Board of Supervisors?
Absolutely, yes.
Okay, I think my history here suggests that anything that can be appealed will be appealed, but good to know, and thank you seriously for the clarification. And then other rec plan amendments?
Yes, Lehigh has also applied for a significant reclamation plan amendment that would modify their operation in fairly significant ways. It would open up a new mining area called the Rock Plant Reserve. It would lay back the northern high wall of the main quarry pit in order to both stabilize that wall and also allow for the extraction of additional limestone. It also contemplates using imported clean fill rather than existing stockpiled overburden material to use to fill the main quarry pit. About 20 million cubic yards of clean fill is what would be required to import to fill the quarry pit. That represents about 600 one-way truck trips per day.
So, just to be clear, the application is for essentially a great big new hole in the ground, yes?
Yes.
And in order to do that, then there are some things that would have to be done, and that includes a change in the reclamation plan and the issue that you described in terms of the scenic easement, yes?
Yes.
Okay. Who gets to decide whether or not that happens? That's a question that people are going to want to know the answer to.
The Planning Commission has the responsibility to hold the public hearing and make a decision on the reclamation plan amendment, but it would be the Board of Supervisors that would have to take the action to amend a scenic easement that the county holds, which covers a portion of the north high wall. So the Planning Commission for the reclamation plan amendment, the Board of Supervisors to amend the easement.
All right. That nicely allows me to segue to Elizabeth Pianka from our county counsel's office. And Ms. Pianka, let me just ask you to comment on the issue of the scenic easement, which, as I understand it, was conveyed to the county by Lehigh back in the 1970s. This issue has come up more than occasionally in recent conversations. Could you tell us what the status of that easement is and if it can be modified, and if so, how?
Correct. The easement was conveyed to the county in, I believe, 1972, and it's to ensure that the height of the ridgeline is maintained at a certain number of feet above sea level. The proposed reclamation plan amendment that Rob Salisbury mentioned includes an amendment to that easement by Lehigh to reduce the height from its current height. And the Board of Supervisors may accept that modification. It's at the discretion of the board.
All right. And I made reference earlier in my comments, introductory comments, to the fact that there were some actions taken by the board prior to my return in 2013. In 2011 and 2012, the vested rights determination and the reclamation plan amendment, both of those resulted in litigation. That litigation went on for a while. Could you just let everybody know what is the status and what was the outcome?
So as Supervisor Simitian mentioned, there was litigation on the board's action deeming certain parcels at Lehigh vested, and that was in 2011. And then separately in 2012, the Board of Supervisors approved the reclamation plan amendment, and that was separately litigated. That litigation went on for several years and concluded in the Court of Appeals. The county prevailed, so the board's actions on both the vested rights and the reclamation plan approval were upheld by the courts.
Okay, and before I leave this issue of the scenic easement, and I'm going to ask folks to be patient while I try and have this conversation and make sure it clarifies rather than confuses. So again, I'm looking for the furrowed foreheads or the nodding like, oh yeah, now it's clear. Ms. Pianka, when these matters come to the Board of Supervisors, we are sometimes told that they are legislative matters, meaning essentially that we have to exercise our best judgment on policy matters about what's good or bad. That's different than something that is a quasi-judicial matter where we have to apply the law to the facts at hand. And there are times when if we can't make certain findings, we have to say, you know what, we have to approve, or if we can't make certain findings, we can't approve. Could you, is there on this easement matter, what are we talking about there?
That is a good question. The easement matter is connected to the reclamation plan amendment, which is a quasi-adjudicative matter before the board. However, the action on an easement, whether the Board of Supervisors conveys an easement or accepts an easement, is a legislative matter before the board.
So sort of a hybrid.
Correct.
All right, and the reason I don't want to belabor this point, but I want to make sure everyone in the room is understanding the purpose behind my question on this is there are times when our Board of Supervisors, and this is true of your local city councils as well, is essentially in a position where we get to say, we're asked to exercise our own best judgment about what is the good of the community, and reasonable people might disagree about that, but you get to exercise that judgment as the elected official. There are other times when someone is going to say, you have to apply the law to the facts, and there are certain limitations on what you can do. You can't give someone a variance just because they seem like a nice person. You have to say, do they meet these 3 tests? And if they don't, you can't give them the variance. If they do, you have to give them the variance. Is that a fairly accurate layman's explanation?
Yes.
Okay, thank you. So when the time comes and you're having opinions about what you hope the Planning Commission will do or the Board of Supervisors will do, I just want to encourage folks to make sure that they're asking themselves and folks inside the process, how much leeway does the Planning Commission have? How much leeway does the board have? And that will be helpful in terms of framing your argument, whatever your point of view may be. Let me go to Mr. Rossi, also with the County Counsel's Office. Anything that you might be able to add to what your colleagues have already shared about these notice of violations? I understand we sometimes use what's known as a stipulated order to comply to resolve a notice of violation. Maybe you can share with us what that is and why we would use one.
Sure. So as Mr. Eastwood said, Lehigh has taken some, but perhaps not all of the corrective actions requested by the county in its notice of violation. The Surface Mining and Reclamation Act allows the parties to agree on a plan to correct any violations. So with respect to the remaining violations that Mr. Eastwood mentioned perhaps exist, we're currently attempting to finalize a stipulated order to comply with Lehigh. which would allow them time to resolve any outstanding items.
All right. Let me go to the U.S. EPA, United States Environmental Protection Agency. Mr. Jones, thanks again for being here. A number of us read in the paper about the settlement that the EPA reached with Lehigh. Please. And my understanding is that the comment period has been extended, so if the settlement is not final, could you briefly explain sort of what the status is and what the settlement was about?
Okay. Really two parts to the answer. My staff gave me the very technical answer, so I'll try to get the layman's terms in here. But process-wise, the settlement was announced in December with a 30-day public comment period. We received numerous comments, and it was obviously over the holiday season, so we extended it another 30 days, and that comment period just is about to close as this week. So that's the process part. The actual settlement was lodged in the Eastern District in Pennsylvania, and the thing I want to make sure there's an understanding of, because I was here a few years ago, and what I couldn't talk about was almost any of this, because it was all in negotiations with Lehigh. This is a settlement with all of their plants across the country, not just Cupertino, Tehachapi here in California as well. And so from states like Alabama, Pennsylvania, across the country, there's 8 states and 14 kilns that are part of the settlement. So that's part of why the settlement took a long time, and that this facility here in California, specifically the one in Cupertino, and we'll obviously hear from Bay Area, our role with Bay Area is to ensure that this facility in this community is complying with the maximum extent they can under the local rules. The rules that apply here are not the same as the ones that apply in Alabama or in Pennsylvania. So the federal requirements that we settled with the company over go across the entire country. The local rules in some areas are different. And so that's part of why the process takes a long time. Another piece of that is the Department of Justice it has a lot of decision makers, and so it takes a while for decisions to get made as well. So I think the main thing I want to impart today is that once the settlement is lodged and then entered in the court in the Eastern District, then the things that are in the public document about what they're proposing to do, there's about $12 million in what we call injunctive relief. That is, things that they're going to do to reduce NOx, nitrogen oxide, and sulfur dioxide at plants across the country. You'll hear more from Bay Area. I think that the plant here is more protected than all of the rest in the country, and those are going to be brought up to the standard that the Cupertino plant is. So the leveling of the playing field, if you will, brings those others up as opposed to this facility up higher. And I think that's an important clarification and an understanding for this community.
Well, before I let you move on from that, I want to sort of bottom line it by asking this question that for folks in the room who care either only about or most significantly about the local plant, will there be a change in air quality as a result of this settlement if and when it's finalized?
I think so.
For the better or the worse?
Obviously for the better. The one component to the settlement that has to be worked out is what's referred to as a test and set for the sulfur dioxide. And so we and DOJ and the state will work with Lehigh to get a sense of, or basically to calibrate and understand how much emissions there are for the SO2 and to put in controls to address that, and that would reduce emissions.
And going forward, I think it would be helpful to know as well, what is the oversight role that the U.S. EPA plays?
Yeah. Our main role with Bay Area is to ensure that they're implementing the Federal Clean Air Act, and in the case of the air standards, we did issue a stipulated penalty under Clean Water Act, a separate issue here, but our main role is to ensure that the local state agencies are enforcing the federal law as it's outlined. Bay Area is more aggressive than other parts of the region and then other parts of the country, so we have a fair good confidence that the work that they're doing is resolving meeting or exceeding the federal requirements.
And when you shorthand to Bay Area, you're talking about the Bay Area Air Quality Management District, also known as BACMed, also known as Bay Area, yes?
That's right.
All right, so why don't we let that be the segue that takes us to the folks from the Bay Area Air Quality Management District, also known as BACMed, also known as Bay Area, and ask if they could explain or elaborate on the Bay Area Air Quality Management District's role in implementing the settlement agreement between Lehigh and the EPA.
Yes, hello, yes, I'll take that.
And we're going to ask you to take that with a microphone that's turned on.
Is it on?
There we go.
Yes, our role we'll incorporate the consent decree requirements into Lehigh's federal operating permit, or otherwise known as the Title V permit. They have a NOx limit currently. The consent decree is actually a lower limit than that, so we'll incorporate that. We'll also incorporate the SO2 requirement. We'll require the facility to submit a permit application to incorporate those requirements, and then our enforcement folks will also continue to enforce those requirements.
On the enforcement side, it's on. On the enforcement side, will be the people out looking at the facility and making sure that they're doing what the consent decree asks for. So we'll make sure that they follow and follow the obligations that are necessary for them to comply with the consent decree. So we'll be out there doing that.
All right, and just again to bottom line it, has there been a change in the air quality over the last year or two from the Lehigh facility, and if so, has it gotten better or worse?
So if you're looking just at the last year or two, I think we have to broaden the scope a little bit. First, if we look at the regional air quality in the region, it's gotten much better over the last 20 to 40 years, okay? You're laughing, but it has. I realize that, and
we're
to
going
say
to avoid
1
we're
year,
going to avoid the back and forth. So, keep answering, please.
to say in 1 year there's been a lot of improvements or no improvements, that's impossible to say because there hasn't been any new requirements in this past year. The consent decree will obviously change that. We will now have controls on sulfur dioxide. So that will be a tremendous benefit to the local population here in the Bay Area.
All right. You can look forward to me asking that question again in a year and 2 and 3, and we'll see what the answer is then. Regional Water Quality Board, my understanding is that there was a notice of violation issued in 2019. Excuse me. Could you tell us if the site impacts, what the site impacts were?
Sure, so that's me. This is the notice of violation that the Robs down at the other end of the table had mentioned earlier. We both issued notices of violation to Lehigh for discharges to Permanente Creek from the WMSA area. For us, it was identified as seeps. It was essentially rainwater that was trickling through the waste material, the overburden material, and then seeping out the side and getting into the creek. They were extremely small, and they were elevated in selenium and nickel, but not extremely elevated, and we think the impact was probably nil. What we were more concerned about was the erosion that was happening there. We thought it was certainly waste material, overburden material, that was discharging to Permanente Creek, but when we went out there, we realized it was actually native material, so that's natural erosion. It does happen. So that notice of violation was actually just resolved today. I just sent out that letter that we found that impacts were minimal, if any, and we had them develop what we call a corrective action plan, which is essentially figuring out what caused the seeps, and like I mentioned, it was rainwater trickling through the waste mass, and so they have regraded the area. They've implemented quite a few fixes for that, and they've also updated their plans to try to prevent something like this from happening in the future. So we're confident that the water quality impact was resolved in that case.
Valley Water, your thoughts on these issues? I get questions almost every year about folks who are concerned about the potential for contaminants like selenium in particular getting into the groundwater and then possibly into the drinking water. What can you share with the public about that concern?
Sure. So metals like selenium don't move readily through soils, and drinking water wells are at a great depth. So we would not expect metals to go down to that depth and show up in drinking water wells. And we have looked at data from all the wells within 4 miles of the quarry, which do not show elevated selenium, mercury, or arsenic.
Let me go to Mr. Lee with the City of Cupertino because we do have the overlapping jurisdiction with the city and the county. I know the city has been very active in reviewing Lehigh's reclamation plan amendments, and I'm curious to know what you think the best way is for residents of Cupertino to share their views and concerns with the city as the county moves forward with its review.
Well, I think we maintain a website with the city. If you go to our webpage, it's and type in the search engine Lehigh, it'll take you to a selection, and you'll see where it has Lehigh 1820 issues. And we diligently keep that updated with documents that the city is forwarding on to the county or whomever it may be. It's listed that way. And then documents that the county is also submitting to Lehigh or Stevens Creek Quarry. And so we just keep a running list of all the different documents that are going on there. You can register there to be email notified that any time that we update information onto that site, you'll just get an email in your inbox that says, hey, there's something there, so you can go there and see it.
Thank you. And I know, of course, or at least I think I know, that the city issued a notice of violation for illegally grading a road on a parcel that's in the city's jurisdiction back in, I want to say, mid-2019. Am I remembering that correctly?
That's
and
right.
If so, could you tell us what the status of that violation where there's a city notice of violation is?
So that would be good to tie into with what Rob Eastwood and Rob Salisbury were talking about with the road. Those that may be familiar with the area, there's PG&E high voltage transmission lines that traverse the area near the Lehigh site and Stevens Creek Quarry, and there is a PG&E road that roughly parallels those high voltage lines, and that was the road that was illegally graded. That then, when that activity was stopped. When Lehigh was transporting materials from their facility to Stevens Creek Quarry, that's when we had all the truck traffic that was hitting our Cupertino streets, and we had a series of neighborhood meetings and were effective in getting that to stop and the notice of violation issued by the county. What some people may not know is there's a portion of that haul road that went from 12 feet wide to roughly 35 or 40 feet wide that is within the city's jurisdiction. So it's not covered by SMARA and what the county is doing. It's strictly within the city's purview.
And SMARA stands again for?
Oh, you shouldn't ask me that. State Mining and Reclamation.
Surface, Rob?
Yeah.
Surface Mining and Reclamation Act.
There you go.
And your point, the reason I'm focusing on this is just want to make a point that Mr. Lee is making, which I think is important, which is depending on what piece of dirt we're talking about, it may or may not be covered by state jurisdiction.
Right.
And thank you. And continue, please.
All right. So while the county may say that notice of violation has been abated, there was some erosion control that went in place prior to the wet season this year to make sure that was taken care of. But the portion that's within the city's jurisdiction, that has not been resolved yet. The city issued a notice, an administrative citation and a notice of violation back in May of this year because they conducted grading without a permit. The work that they did not meet design standards. We were concerned with the stability of the slopes and the fills that they had. It didn't have the proper erosion control, and it also was unauthorized removal of quite a few trees. So we issued that citation. They had 30 days to make an application, and they did that. there was some back and forth because we didn't have the tree information that we needed to do that enforcement. And where we are currently with that process is, at first, our first desire was just to take that road back to its precondition prior to the illegal grading, get it back to a 12-foot road. That makes sense. What's challenging is that, the cuts against the embankments have already been made and the fills on the downhill slope have already been filled. It's easy enough to remove the fill on the downhill slope. You can just remove that and get it back to the existing ground. What's more challenging is putting the cut that was on the uphill slope back in place, because you just can't, stick it up to the side of the hill. You would have to bench it and then compact it, and you're chasing the slope up the hill, and then you're just disturbing more area. And our goal is not to disturb more area. Our goal is to disturb less and get it reclaimed earlier than not. So what we're working with Lehigh is, and we're agreeing on an approach as to where we can resolve the downhill slope side, take it back to existing grade, and the uphill side will disturb as little as possible. But there will be some retaining walls on the uphill side to stabilize that soil. What we're waiting for is for that those designs to come back from Lehigh to the city so that we can evaluate it, and then we would then make sure that it meets our requirements, and then we would calculate what that new fee would be for that grading permit, and then we would issue the permit.
I'm going to ask you to stop right there, please, just because I want to get to community questions, and we've got just one or two more questions for the panel first.
If you would, just let me add that our goal, April 15th, that work would begin, and we want it to be done before the start of the rainy season next year.
Thank you. And county environmental health, we've had quite a bit of discussion in previous years about noise. Could you just please let us know about the current monitoring program, and also let us know what the results of that monitoring program have shown over the past year?
Thank you. In 2019, the Department of Environmental Health continued with our monitoring sessions. Reports of these sessions are recorded and also posted on the Department of Planning and Development website. So you'll see the quarterly reports posted there. In 2018, we received no complaints, and this was a result of the significant structural changes that were done by Lehigh. In 2019, we received 12 complaints. The last monitoring session that we conducted in December 26th, an exceedance of the noise limit was recorded. As a result, a notice of violation was issued to Lehigh. Upon issuance of the notice of violation, I communicated with Lehigh, and they indicated that they did not have any structural or operational changes. They're also conducting their own monitoring sessions with a third party that goes out once every quarter, and also their own in-house monitoring, which they do once a month. Received a response from Lehigh this week on the NOV, and we will continue working with Lehigh on this issue.
Thank you. And let me also ask County Environmental Health, we also turn to you on questions of hazardous materials. And I guess since it's been a year since we've had our last meeting, any update on what's taken place on the site over the course of the past year on hazardous materials?
Sure. And just for context, we break up the campus into 18 different areas, and we implement 6 primary state environmental programs related to hazardous materials, as well as a local hazardous materials storage ordinance. And it's all focused on preventing hazardous material releases, as well as minimizing the impacts of releases when they occur. And when we're talking about hazardous materials, we are talking about the more industrial chemicals, rather than perhaps the levels of selenium that might be impacting the streams from runoff. We were in the middle of performing, I should say that our programs have a variety of inspection frequencies ranging from once a year, so we're always out there at a minimum of once a year looking at their underground storage tank that holds fuel, to some of our programs have mandated frequencies of once every 3 years. Last year, when we were here at this meeting, we were in the middle of one of our more comprehensive triennial inspections, where we go through pretty much every portion of the facility, looking at all of their procedurals, a lot of paperwork, operations, plans, and how they're doing things to minimize releases, as well as the physical or engineering controls things like the construction of their tanks and containment and sensors, alarms, all of that to make sure their hazardous materials are in good order.
Excuse the interruption. Triennial meaning?
Every 3 years?
Every 3 years. And if I remember the public or even a member of the Board of Supervisors, I might say, is that often enough? So, serious question.
It is the frequency that is established in state law.
Would it be possible to do it more frequently if it was the will of the board?
I'm not sure. It could be. We would have to adjust our fees accordingly.
Okay. So that was a very polite and gracious and professional way of saying, take it up with the county council, and thank you for that response. I appreciate it. It's helpful. Seriously.
Yeah, we are out there frequently just because not all of our inspections happen at the same time. We do construction projects. So we perform routine inspections. We perform inspections related to construction projects as well that deal with hazardous materials. We deal with complaint investigations as well. So even though there are programs where we're not out there except for once every 3 years, we are out there much more often than that. So since January of 2019, we have performed 47 routine inspections across all 18 of those buildings or facilities, 8 construction-related inspections, including final inspections on 3 separate construction projects, including the lower selenium water treatment plant to make sure that the chemicals that feed into that system are properly contained and have mechanisms to prevent them from overflowing. We oversaw the installation of an oil water separator, and their diesel tank also had an overfill prevention mechanism that needed to be replaced. So during these routine inspections, and I should say because we're dealing with a lot of paperwork, almost all of our inspections result in violations. That is normal for our inspections, not just at Lehigh, at all of our facilities. And so we provide them with a notice of inspection that outlines all the violations, give them a period of time to come back into compliance, and then we go from there. If we have significant violations where there are more serious releases of hazardous materials to the environment or that cause human harm, or there's a facility that's failing to take adequate action to correct those violations, that's when we will escalate our enforcement. That could include anything up to an administrative enforcement order with civil penalties or a referral to our district attorney's office along with them potentially issuing penalties. In the case of the Lehigh inspections, most of those inspections took place between January and March of last year. There's another inspection that took place around October for the underground storage tank. All but one of the facilities did have minor violations. About 8 of them had what we would call moderate violations, but there were no significant violations that we identified at their facilities. Most of those violations have been addressed and were addressed in a very timely fashion. Some of the more construction-related issues take a bit longer, so we have maybe half dozen violations primarily related to the interim selenium treatment plant and kind of converting that from an interim plant to a more permanent plant and making sure that everything went through the proper process and that all the necessary containment and sensors and overfill equipment is installed and in good working order.
All right, I'm going to get to the questions. Thank you all for your patience, but I think we covered a lot of ground with those questions. Thank you again. I'm going to just try and pop as many of these off as we can, and I'm going to ask you to give crisp answers, and I'm going to try and restrain myself from interrupting you in your answers. That'll help too. Here's not so much a question as an exhortation. Please tell me the county will uphold the 1972 Ridgeline View easements. Planning Department, what do you have to say about that?
As Ms. Pianka stated earlier, it's ultimately the discretion of the Board of Supervisors regarding Lehigh's request to modify that easement.
Okay, so we have an existing easement. We have a request to change the existing easement, and ultimately that is a determination that will be made by the Planning Commission and the Board of Supervisors, yes?
The easement is solely the determination of the Board of Supervisors.
Best news I've had all night, I'm sure. Thank you very much. All right. Next one. Why has the county never fined Lehigh for its multiple recurring violations of SMARA? Planning, and then I'm going to go to County Council as well.
So each time there is a SMARA violation, they are subject to fines. When we do issue violations, we give Lehigh as any quarry operator to enter into a stipulated order to comply to address the corrections needed. If they don't and they do not correct the actions, we can fine them. To date, on both of the violations, they are continuing to work with the county and follow direction. We are not fining them, but at any time we find they are out of compliance, not following county direction, we can fine them. That's both in our state law and county code.
The question posits that the county has never fined Lehigh on a SMARA violation. Is that accurate in your understanding? Never is a long time.
Never is a long time. I can't answer that question accurately over a long time. The two recent violations, we have not fined them. I'd have to go back and look to see to past violations.
All right. Anything else from your colleague on planning, or he's looking like he'd be happy if I went to Mr. Rossi in the county counsel's office. So you're going to get your wish on that one. Mr. Rossi, county counsel's office.
Mr. Eastwood again stole my thunder. I think he adequately described the county's actions under SMARA.
And have there been fines have there been other fines that are not SMARA related? Or is the answer to that question no as well, at least in the recent past?
With respect to other fines for violations of the county's ordinance code, as Mr. Eastwood said, if the quarry is willing to enter into a compliance agreement, which is the county's version of a stipulated order to comply, we generally allow them to abate on a time certain before we impose fines. In recent history, during which I've been involved, we have not issued fines because they have complied.
All right. Question is, at what point can county council review their vested rights and terminate the mining that employs only 25 people, mostly out of state, so on and so forth? So, county council, vested rights, is that subject to review?
The vested rights determination that was made by the board in 2011 is not subject to further review.
That being said, and Ms. Bianca, work with me here a little, please. That being said, the fact that someone has vested rights doesn't mean they have vested rights to do anything in that site. They have vested rights to do some limited something, yes?
That is correct.
Can you help describe that a little bit more? I'm going to be a little bit silly here, everybody. So, for example, if the application said we'd like to put a Bloomingdale's there, would that be allowed because they have vested rights?
The determination in 2011 was for surface mining activities and operations.
Okay, so it's limited in that way, yes?
Correct.
And then what about the scope of the vested rights? Not just the nature of what they do, but the how much of it they do. And at some point when you tell me it's confidential, I'll look at everybody and say, shh, okay.
It is a question of substantial change and what constitutes a delta. So it is a vested right for surface quarrying mining operations at the site, and it's a question of what would constitute a substantial change to that.
So would it be fair of me to say a vested right means you get to keep doing what you're doing, but it doesn't necessarily mean you get to do something different or something that is significantly greater in its scope?
Potentially, yes.
Okay, that was a good lawyerly answer. Thank you very much. And questions about water. 4 years ago, Lehigh was ordered by the courts to restore mining ravaged Permanente Creek. When will the creek be restored? Somebody in the water world want to answer that question? Don't all jump at once, okay? Planning, all right, go to it.
So Lehigh has applied for a grading permit through the county for a portion of Permanente Creek. There's also a broader Permanente Creek restoration plan that has been under review by the county and other jurisdictional agencies for quite some time. We have recently deemed that application complete, and so the next step in that process would be to issue a notice of preparation for environmental impact report. So it is moving forward, and we hope to have a notice of preparation for that EIR within the next couple months.
Okay, I'm going to follow up with an unfair question. Get ready. So if you had $5 in the office pool, when will the creek be restored? Best estimate. Give us a range. Order of magnitude. please, from the,
In the current approved rec plan, I think it speaks to sometime in 2030.
all right, thank you. Okay. And for the Water District, question is, what are the plans to test water in Stevens Creek for heavy metals, especially the portion of Stevens Creek that runs through McClellan Ranch Park? Testing for heavy metals, Stevens Creek.
There's ongoing monitoring of Stevens Creek through the Santa Clara Valley Urban Runoff Pollution Prevention Program, and the Valley Water monitors the reservoir twice a month during the summer and once a month in the winter for mercury and just other pollutants.
So did I understand correctly then that the monitoring is currently happening? Yes?
There is some monitoring currently happening. I'm not sure exactly of that location.
All right. I have a question here about air quality, and someone wants to know, how do we report air quality violations that happen after hours?
After-hour complaints are accepted 24/7, you know, every day, every night, every weekend. We have after-hour complaint line, 1-800-334-ODOR. That's our complaint line. During normal business hours, it's answered by a dispatcher, and complaints are immediately dispatched. After hours, complaints are taken by our answering service. They will be dispatched the following day to an inspector, or the following business day to an inspector. If there's anything ongoing that's serious, it will be forwarded on to a supervisor. We have a supervisor at all times working after hours, and if he deems it necessary to send someone out, we can send somebody out.
All right. We have some that cut across the various agencies. One of the questions is, how can the public weigh in with these various agencies as the application for expansion goes forward? So when, where, and how? Planning?
Thank you. So there'll be several different opportunities for the public to weigh in, several different formal opportunities. The first will be when there's a notice of preparation filed for preparation of the environmental impact report. Typically then, after that, when the environmental impact report has been circulated for public comment, there is a public comment meeting, typically hosted by the County Planning Commission. And then also when the application itself is scheduled for a public hearing before the Planning Commission, the public can comment at that time as well.
And those are all public meetings?
Yes, they are.
And the planning department, and I'm looking at our planning director, will publicize those widely?
Yes.
And will some of those opportunities be here in the community as opposed to at 70 West Heading Street, which is not always that convenient for community residents?
I think likely at least the notice of preparation meeting will be here, although of course we have not yet finalized that date or the location.
Okay. And I'll just say to folks who are here, I look forward to working with our planning department to make sure that there are opportunities for people to participate that are close to home so that folks don't have to get to the County Government Center in San Jose during business hours and in traffic that's more than challenging some days. And who oversees blasting on the site?
That's a good question. They are allowed under their current reclamation plan, acknowledged to do blasting. I presume in accordance with air district laws, there might be some requirements. The blasting is subject to compliance with the county's noise ordinance and can't exceed those. But under the current terms of they having vested rights to Quarry, the reclamation plan, they can do blasting. So in a broad sense, the county has oversight, although with respect to, of course, with respect to noise, they have to comply with the noise ordinance, and they're looking to the air district if there's some air quality requirements that would also apply.
Yes.
So in terms of blasting, Air District has some oversight. If the winds are too strong, if they're greater than 25 miles per hour, they're not allowed to do blasting. We will, the good news is that once our Title V permit, and we can talk about the Title V permit if you'd like, but once a Title V permit is approved, or the fugitive dust plan contains a 3-year study that Lehigh has to do regarding blasting, and they will be looking at ways to mitigate fugitive dust from blasting operations.
What is fugitive dust?
Well, it's all the dust that you see when you explode dirt.
So it's dust that's headed off out there somewhere, yes? That has escaped, hence fugitive dust?
Fugitive dust, the way we understand it is fugitive dust is dust coming from other than a specific opening. Like a smokestack, if there's dust coming out of a smokestack, that's not fugitive dust. But if it's coming out of the sides, out of the vents on the sides, we would call that fugitive dust. We would call any road dust from traffic, from trucks, that would be termed fugitive dust also.
Okay. There is in this big stack one question for me. What is your view of Lehigh? Are they good or bad? Should we allow them to operate near a residential area in Cupertino? First, and I do not mean this disrespectfully, my first view is, gee, I wish they were in somebody else's district. Because this is a very challenging dynamic to have a residential area immediately adjacent to a quarry and a plant. And so, I'm only being half joking, half serious, I guess, when I say I wish it were in some other district, because as your district supervisor, while I do not get to make any of these decisions as an individual member of the board decisions can only be made by 3 or more supervisors. It does fall on me, in my view, to try and make sure that people are informed, that people have access to the information, and that our county planning department is doing its job robustly. I am not the boss of them, just to be clear. Only the county executive is the boss of them. But it's a challenge, frankly. It's a large, challenging issue, as many of you in this room would know over the course of a great many years. Here's what I would say. Many of us in the room inherited this challenge, and I'm a rule follower. And I think we should all expect anybody in the community doing business to follow the rules. If folks aren't following the rules, then it's important that we make sure that they follow the rules going forward. So if you were to ask me what I think my job is, much of my job in my judgment is to make sure that people follow the rules. One of the reasons I spent as much time at the front end of the conversation talking about decisions that had been made prior to my return to the board was so that you all would understand what not just you, but I, as your elected official, inherited in the way of certain givens. I think almost any of us, including the folks at Lehigh, would probably say, in a better world, we wouldn't have an intense operation like this, cheek by jowl with residential neighborhoods. I don't think that's a particularly ideological or pointed point of view. I just think, however that came to be over time, it has occurred, and now we have a very challenging situation. And with that very challenging situation, my expectation is everybody will follow the rules. When we go forward, we'll have some decisions to make. And as you heard me distinguish earlier, and I did it for a reason, some of those are judgment calls that I get to make with my colleagues. And again, I should remind you, there are 5 supervisors. I'm the only one that represents this area, but all 5 get to vote. So please be mindful of that. There are other issues where I'm going to turn to county council and say, I need to understand what the rules of the road are, because I'm going to follow the rules. Sometimes I vote for things I'm not all that wild about, but I feel like I have to under the law. There are other times I vote against things that frankly don't trouble me that much, but I feel I have to vote against them because I have to follow the law. So as you are trying to figure out how to lobby me in my office, I hope that's helpful. And I would encourage you to be sort of mindful about the fact that there are 4 other supervisors who will be part of this process. And on land use matters, as I say, while we have 5 district supervisors, only one of whom may represent an area, all 5 will ultimately vote. That's how I feel about all this. That being said, we have a question about air. And the question is, can the Bay Area Air Quality Management District tell the public what's going on with Lehigh's Title V permit? Draft, has it been cleared with EPA, and how soon can the public read the new permit information on the web? And here I just want to brag on my constituents a little bit for the county staff who are sitting here. You know you're in my district when people start saying they want to read the draft of the EPA Title V permit documents. So, where are we?
Yes, we had 2 public comment periods, and then we sent it to EPA for their comments. That period has since closed, and we're in the process of finalizing it, and we'll post it to our web, and everyone could read it.
Okay. Well, this one's for the this one is for the US EPA, and this may be the only time I say this all night. If you want to take a pass, I'll understand. The question is, can/will President Trump cancel out all the air pollution controls?
Good question. Well, the way anything works in Washington, at least in terms of the statutes, the laws, those are all written by Congress. And so any changes in any statute, anything that our agency implements is a congressional decision. There are executive orders that the president can issue that whether or not they're followed closely or directly, they can't interfere with the law itself. So no.
That flows nicely into the next question I have, still for the EPA, if you will. If there is a major change or revocation of the Clean Air Water Act, will the EPA settlement terms change? So you have a settlement, it's almost
Right.
but not quite final. If there was a change in the Clean Air or Clean Water Acts, would the EPA settlement terms change?
Let me just kind of clarify. So there really was a recent announcement on the Clean Water Act, the Waters of the U.S. rule. So it was specifically changed in a way that does impact waters of the U.S. as it's referred to. And so that in our region is significant. So places like Arizona in particular, where waters don't run perennially, that area is less likely to be protected than it used to be, because we're looking at navigable waters as the definition for the Clean Water Act, and it's been restricted to just basically rivers and lakes, large water bodies. For the Clean Air Act, there hasn't been that level of change, and I don't anticipate that.
All right. County, question is, how can Lehigh have vested rights to mine when they, in the view of the questioner, so persistently violate and have violated the terms of their air and water permits? And to just shorthand that, it's like, do the vested rights continue to be there? Do they continue to have vested rights notwithstanding the violations that you've articulated?
Yes.
Okay. What else do we have? I'm going to say no thank you, please. We use the cards for a reason. And again, folks will stay, ma'am? Ma'am? Is this Ms. Lee? Ms. Lee, I understand. Okay. All right. Folks. Folks, just so you know, this is someone my office has been interacting with over the course of some period of time. Sorry for the disruption, and I'm hoping that there's a compassionate way to work through the issues there. So again, my regrets for the interruption. Let's get back to questions that we have. So to the panel generally, do you feel that the penalties are adequate to serve as true deterrents to the violations? And what limitations may apply to Lehigh, if any, on spare the air days? So 2 questions. The first one is, are the penalty, and if you want to say where the penalty amounts come from or how they're determined, but are they sufficient to deter violations? So let's start with that one, then we'll go on to the second question. Panelists?
So for air quality, our penalties are determined through the California Health and Safety Code. The California Health and Safety Code outlines the penalties that we can collect. For instance, there might be at the lowest level, strict liability, and we can collect up to $5,000 per day per violation. But it will run through willful and neglect and negligence, and so it will run up to I think if there's actually bodily harm, it could be very, very expensive. But none of that has ever happened at Lehigh. So the other thing that we look at when we assign penalties is we look at mitigating factors. So not only are the Health and Safety Code outlines the potential penalties, but it also outlines the mitigating factors that our legal staff has to take into account before they assign a penalty. So that's how we do it. And the penalties, usually, I can just say for the penalties or the violations found at Lehigh, our legal staff usually will take several or a batch of violations and settle them all at once as a batch.
The second question is, what limitations, if any, apply to Lehigh on spare the air days?
So that's a question that comes up a lot. Spare the Air Days are really a voluntary program for the public, and it has nothing to do with stationary sources, so stationary sources do not have to stop operation on a Spare the Air Day.
So just to cut to the chase on that one, what I heard was limitations imposed by Spare the Air Days do not apply to Lehigh. Yeah, is that correct?
That's correct.
Okay. Then, the card says, well, all the diesel trucks are regulated by CARB, the California Air Resources Board. Why aren't they here? So I think that's a nudge to me in my office that we might see if we could get the folks from CARB to participate. Thank you for that. And then it says, who regulates Foothill and Stevens Canyon roads as a, I think it says line source, especially when they're driving so many trucks? Who's in charge of those roads? Lee? Mr. Lee, excuse me.
Yes, the intersection of Foothill and Stevens Creek Boulevard is within the city limits.
A little louder, please.
Yes, the intersection of Foothill Boulevard and Stevens Creek Boulevard are within the jurisdiction of the city of Cupertino.
Okay. And the enforcement there falls on who?
Well, if it would be traffic enforcement, that would be with our sheriff department. If it's like the traffic signals and maintenance, that would be with the city.
Okay. So there's a card here that first posits that it's very helpful to have these annual gatherings of all these agencies, but the impact is so large, so complex, and long-term. Could there be an alternate oversight and enforcement model, such as the California State, Federal, County MOU, meaning a Memorandum of Understanding? Then there could be dedicated experts and staff that would enforce that MOU. Are there other models that folks know of that are used for regulation? I think the question goes to the fact that there are so many disparate agencies and trying to make sure that each one is working in coordination with the others and that every issue is actually covered by somebody effectively. It's one of the reasons why I asked for the twice annual meetings to take place among all these folks when I came back on the board. Thank you again for that. It's also the reason why I asked them to all be here for this kind of an annual meeting. But I guess the question is might there be a better way, rather than hoping that literally a dozen different entities can all be counted on any given day, to have their eye on this particular operation?
I can just say from the federal standpoint, our view, and it hasn't changed much over the time I've been at the agency, it remains that we believe, most of the people who work at the agency believe these are local decisions for the most part, that the federal government's role is limited. And so to the extent we're involved, it's when the state or local authorities are not meeting what we believe is a national standard. We wouldn't assume that you would want the federal government in street oversight and traffic. It would not work well.
All right. I will take some time later to think through that question, because I do think there's value in thinking about other models. And I do think, as I mentioned earlier, there's a challenge getting, we used to say the left hand and the right hand know what they're doing, but we got kind of an octopus going on here, and I'm not quite sure how that works. So thank you for the question. We have a question about the situation with the woman up front, and I can just assure you that things are fine. So I'll let that go. Then we have yet another question, which is, how can or will the progress, and this is for the folks at the Air Quality Management District, I think, how can or will the progress with the air quality actually be tracked once the settlement is final? How do we know how our air is improving, and if it is? So the settlement will be final. How do we know then that the conditions of the settlement are being realized? And how can we track that going forward?
I mean, initially, the settlement will work with, obviously, with Bay Area Air Quality Management District to ensure that they're in compliance with their new permit. If there are violations of their permit or of what's called the consent decree, so what they're agreeing to is called a CD. If there are violations of that CD, we could issue penalties, we in the Department of Justice. And so we will be monitoring that throughout the time of the life of the CD. And then obviously anything that happens locally with Bay Area, we would help and coordinate with them.
Anything from the Air District?
So, yeah. So the consent decree will have some obligations on Lehigh to reduce their NOx and to reduce their sulfur dioxide. We have continuous emission monitors that are required on the stacks out at the facility, and we will be able to determine whether or not they're complying with the obligations of the consent decree, and they'll also be put into our own permit conditions eventually. So that's how we determine whether or not there's compliance with the consent decree.
And just to be clear, so there will actually be a monitoring of the air quality after the settlement is final to determine what the impact has been on air quality, yes?
That's correct.
Okay. Next question. Any plan, and this is for both the Water Board and the Bay Area Air Quality Management District, any plan to monitor mercury pollution from Lehigh? And if so, which agencies would be involved? But I'm going to start with those two and see if anybody else wants to step into that one. Mercury pollution.
So Bay Area Air Quality certainly has a regulation, Portland cement manufacturing regulation that has specifications or requirements for mercury pollution. And so we've taken a strong role in that, and mercury pollution over the past 10 years has been reduced around 90% or so. So there's been a great reduction in the amount of mercury that's been emitted to the air, and that's through our Portland cement manufacturing operation regulation.
And let me just ask, mercury is a source of particular concern, as I recall, yes?
It's a toxic air pollutant.
Thank you. And so when we say 90% reduction, does that meet the standard then?
Yes, they're meeting the standard.
And looking at it, 125 people here. Does that mean that you feel that the levels of admissions that are currently occurring are not unhealthy or unsafe?
I'm not really the person to determine that. I determine compliance. But I think we do have a health risk assessment that's being evaluated at the present, or will be shortly, and that certainly will determine whether or not there's any health risk to the residents in Cupertino.
All right, thank you. Bear with me here. Thank you. Water folks, thank you.
Lehigh's discharge permit already requires them to monitor for mercury, and they have consistently met the limits, and it does not appear to be a water quality issue.
Okay, thank you for that. Bear with me here. I'm trying to consolidate questions where I can. This one is a new traffic signal still proposed at Highway 280 and Foothill Expressway to regulate new truck traffic caused by the importation, of soil to fill the Lehigh pit?
I'm not aware of that. If it does go that far, it's a potential, but that's not something that we would even recommend happening from the city.
All right. I think this one is for the county. We keep hearing that Stevens Creek Quarry's permit is expired many years ago now. Why are they able to continue operations? Planning, please.
Okay. Yes, Stevens Creek was operating under a use permit. It was set to expire several years ago. The quarry actually came into the planning department, applied for an extension. The extension at one point was actually scheduled to be heard by the planning commission, but during that process we did discover several issues with the reclamation plan. And the use permit and reclamation plan are interlocking in many senses, and we did not want to take the use permit extension forward to the commission while there were issues with the rec plan, because one would affect the other. So we had recommended to our planning commission to continue the item. They did. We continued to work with the quarry operator on the rec plan. Did discover several slopes instability issues, and we actually have issued a separate violation to Stevens Creek Quarry with respect to slope instability. And nevertheless, during that process, the use permit per the county zoning ordinance codes expired, even though they had applied for an extension because an action wasn't taken. We directed the quarry to enter into a compliance agreement. Mr. Rossi has mentioned that before.
And this is the Stevens Creek Quarry.
This is Stevens Creek Quarry. And the compliance agreement directs them to continue on a path to apply for a modified rec plan, apply for a use permit to address the violations, and bring the quarry into compliance. And as mentioned earlier, if they continue to comply with that compliance agreement, it provides them shielding from shutting the quarry down and from fines. To date, they've continued to comply with that compliance agreement. It has them on a path to apply for the use permit and rec plan, which will ultimately be considered by the county for approval.
So just to be clear, there was an application for a new plan prior to the expiration of the previous permit?
Correct. It was an application for an extension.
Thank you. And the issues could not be resolved prior to the previous permit expiring? Is that what happened?
That is correct.
And so the agreement that is in place is designed to address those issues that were unresolved as of that permit date?
That and new issues that have been identified on site.
All right. For county council and the county generally, well, so have there ever been any cases where vested rights have been taken away from an owner? Is it possible?
I am not aware of any cases where a vested rights determination has been repealed or rescinded.
Okay. We have a question from someone who is addressing this to the water quality folks, and they indicate that in their view, Lehigh still has a selenium pollution problem, and you find them, but that doesn't stop the pollution. So what can be done and what are you planning to do to actually stop the problem? The Lehigh treatment plant, in the view of the questioner, is not cleaning this up. Why is that? Water quality?
Yes, it is accurate that Lehigh has had some minor violations of their selenium limit, but I want to emphasize the minor. They historically had very significant violations of their selenium limits, and that is why the treatment plant exists, and they've invested in the treatment plant as well as in significant drainage changes to capture water differently so that they can treat most of it and or retain what they can't treat before it discharges so that some of it settles out. So the data that they continue to provide to us under order of their permit does demonstrate most of the time that they are meeting those limits. The limit that they are exceeding in occasional amounts, and when I say occasional, it's been 3 to 5 times in the past year and a half. And what was I going to say? Oh, the limits are set at levels to protect aquatic life in the creek, which are lower than limits that we would be setting if we were using that water directly for drinking water. So the limits that they have are very low, very conservative, and they've reduced the concentration of selenium in the water that discharges from the site significantly through their treatment. We are not absolutely convinced that there's reliability for the long term because of these exceedances, so we're continuing to monitor and do our due diligence and oversight of their compliance with that permit.
Thanks. Let me ask, again, because I can see the faces, when various of our panelists have used the word minor, or words minor violations, I think that can be a little vague or ambiguous. It's not critical, it's just, I can see people sort of like, I'm not sure my definition of minor is the same as your definition of minor. Is this a term that people use that has some precision? How can people, I mean, you know, if I said Councilmember Darcy Paul got a jaywalking ticket, he didn't, by the way, people would say, well, that sounds pretty minor to me, they'd make that judgment. If I say he got a ticket for doing 95 in a school zone, which he didn't, by the way, they'd say, that sounds major to me. People would exercise their own judgment about that. So we have all these various violations that keep being referenced. Should people just expect that that's a routine part of an operation this size? Just like the restaurants we go to are going to have minor health violations? Or is there some way to be more precise about that when we're talking to people and give them some greater assurance or understanding even of what it means when we're talking about minor versus major violations?
I'm going to give a really specific answer that is not generalized and may or may not apply to how anyone else on this dais has answered the question. But in the case we're talking about, the violations that have been exceeded were for daily limits. So what that means is on a day, that particular day, the 3 to 5, maybe it's 7, no more than 10 times it happened on that day, not the next day, not the day before, and not again for several days throughout more than a year.
So point being, there actually is a definition that goes with the phrase minor violations, or no?
Well, when I was using minor previously, I was using it more generically. But,
okay.
But there are different levels, and at that level.
Others on the panel?
So when I was speaking about the notice of violation earlier, I also said that there were minor violations, and in my usage of the term was essentially that these were operational violations. We didn't expect an impact. We didn't see an impact, but they're violations because they have certain protocol that they're supposed to follow in order to be protective of water quality, and so when those protocols fail or they fail to implement them properly, in this case it was the protocol failed, then that's still a violation. Again, no impacts, but they weren't doing enough to be protective, and so what that did was when we say we want to bring them back into compliance, it's essentially taking the actions that they need to take to prevent it from happening in the future. So that's why it's minor.
All right. Ms. Pianka and/or Mr. Rossi, back to you again on the issue of vested rights. Can voters overturn vested mining rights? And if we don't have answers tonight, folks, and I'll mention this a little later, we will get answers, as I think I indicated earlier, and get them posted for you. So I want to give the panelists the ability to say, we'll get back to you on that if there's a pause. Ms. Pianka.
Thank you, and we would like to get back to you on that.
Okay. I kind of thought that one might be coming, so, but I think you see that there's some interest in this subject. Question from the questioner is, and I think this is for almost every and any member of the panel, is there any data available on any higher than typical or adverse health impacts from Lehigh? So has someone drawn a circle around the plant and then identified health impacts and been able to compare or contrast them with other areas that are not inside that circle? That's my sort of layman's way of describing that. Anybody? Well, let me help environmental health feel like they should lean in and answer that question. Environmental health?
The Hazardous Materials Program does not do health assessments. We are a regulatory agency that enforces the laws that are on the books as determined by our legislators and the regulations implemented by Cal EPA.
All right. Anything else from environmental health on that?
No, sir.
Okay. I think what I'm going to do is turn to my staff and say, why don't we consider that one of the unanswered questions that we can get a little more information on and see if we can't get a response up on our webpage when the time comes. Question: if the easement for the Hall Road is denied, does Lehigh and Stevens Creek Quarry need to reclaim now, or do they get to wait until they stop mining years in the future? Mr. Eastwood?
And just to clarify, I'm not aware of an easement that affects that area.
Okay.
I'm trying to, so I think the question is asking if the reclamation plan amendment was denied, would they have to reclaim? And I guess the technical answer is no, but every quarry does have to have a reclamation plan, so I cannot foresee a scenario where the county would not say you could not reclaim a mining disturbance.
I think what the question may be getting at, and I'm trying to read between the lines here a little bit, is in your earlier comments you indicated that in order to create the road, which road creation was the basis for a notice of violation, there was disturbance in that area. So if they don't get the road approved, does the disturbance, does the stuff that got moved around have to be restored to the state it was in before the road was put through?
Yes.
Again?
Yes.
Thank you. All right.
And that would apply to the city's portion as well.
All right, thank you, and we've heard from City. Folks, if you are looking at your watches or the clock on the wall, that pretty much brings us to the 9 o'clock hour when we promised we would wrap this up. Mr. Eastwood, I see you leaning in, and I want to make sure that we give you a chance to lean in, so please do so.
I just wanted to clarify, we talked earlier about the county processing the reclamation plan amendment and public outreach meetings. I will go ahead and state that when we conduct those early outreach meetings, we will have them in Cupertino. We hopefully want to use this facility, but we do not intend them to have them back at the county facility. We will come out to this area and hope to have that outreach meeting here.
Thank you. I think that's important and reassuring. And so at this point, what I would like to do is say thank you again to all of you for being here tonight. I want to thank the City of Cupertino again for hosting us. I do think, as I've hinted or suggested a couple of times, that it's important for us to hold these meetings in community places that are convenient for folks. And we have heard from some of you before that the County Government Center doesn't usually fit that description. So thank you for that. I also want to thank all the panelists. And as you saw, there were folks who only had a question or two. They may not have been disappointed by that, but they only had a question or two. I think I should tell you their participation in a meeting like this is a little unusual, actually. When we first asked, people weren't sure what we were talking about, and I said, no, really, I represent nice, thoughtful people. They will ask you nice, thoughtful, probing questions, and they'll hope that you have good answers. So I appreciate their willingness to participate because their presence is really sort of essential to the whole mission of this conversation, and I hope you will join me in giving them a round of applause to say thank you for being here. I want to go back very briefly to that question I was asked earlier about my own views on this, and I think the shorthand that I would like to send you all off on is, at one level, it's really pretty simple, which is I think the operators should follow the law, and I think the regulatory agencies should do their job, and that's kind of the way I come at all of this. So if you're looking for a short version, that would be my shorthand takeaway. Thanks again to all of you for being here. I hope you feel a little more confident that you have some understanding of the alphabet soup of public agencies who are here doing their jobs. And as I mentioned, we will take all of the questions, and the ones that we didn't get a chance to answer tonight, we will make sure that we get them to all of the appropriate agencies, and the answers to those questions will be posted. It will take us a while because you have asked a lot of questions. Many of them are very complex and technical, and we want to make sure that we get thoughtful and thorough responses, and that's going to take a little bit of time. But if you want follow-up, please go either to the Planning Department's page or my webpage at the county. You'll be able to get answers there. And with that, I will say thank you. Have a good evening. Sorry I was not at the top of my form tonight, but I think we still got a very good result. Thank you all once again.